Good afternoon, everybody, and thank you to be here. I have the pleasure to moderate this panel on power, convenience, and prestige in the governance and regulation of AI, and to introduce our speakers of today. But first of all, I would like to thank the University of Turin and Professor Ugo Pagallo for organizing this panel. The title raises several questions, but also offers some suggestions on how to approach AI regulative challenges. Power, convenience, and prestige are free lenses provided by legal theory and comparative law, through which we can better understand why and how a jurisdiction adopts or develops a specific governance model. But now, our speakers. Our first speaker is Zoe Cardasiadou. Dr. Cardasiadou is at the Data Protection Unit of DG Just at the European Commission. Then we will have Professor Fumio Shimpo, who is a professor of law at the Keio University in Tokyo. Professor Julie Cohen. She is Professor of Law and Technology and Faculty Co-Director of the Institute for Technology Law and Policy at the Georgetown University Law Center in Washington, D.C. And finally, Daniel Sprick. Dr. Sprick is a research associate at the Chair of Chinese Legal Culture at the University of Cologne in Germany. Now, I will give the floor to Zoe Cardasiadou. Oh, sorry, please.
This is going to be one of those moments when the panel tries to make you feel sorry for them. If you're up in the back, we see you as like a little head floating on top of a weird wooden bar because this room is terrible. So if anybody wants to make the panel feel better, if you come down and sit in like the first 6 or 7 rows, then we would feel like we are talking to human beings, and that would be awesome. And then later when we have the Q&A, we can actually see you. So thank you so much for considering.
Thank you, Julie. Okay. So, thank you to Zoe Cardasiadou, who will introduce us to the adoption of AI Act in Europe, and she will focus on its extra-territoriality aspects. And no, oops. No problem.
Amongst others, yes.
Yes, okay. So, please. I'm sorry for the misunderstanding.
So, no, I was asked indeed to give here as a first panelist an outline of the AI Act, which was, as you might have seen, was formally adopted by the Council of the European Union this week, and now it has to be published in the official journal to become a law of the European Union, and it will then enter into force in 20 days after the publication. And please, this should not be mixed by when the AI Act should be also entered into application. This will take a bit longer, yet not that long. It has, let's say, a layered approach. There are rules specifically on banned AI systems, which enter into application in 6 months from the from entry into force. Then we have another deadline that is in 18 months for the rules on high-risk systems, and 24 months, and finally 36 months for AI systems that they fall within what we call harmonization legislation and are included in the Annex 1. Why is this important? Because these are also high-risk systems that they are also regulated because of the area of deployment by other acts. That said, and I'm coming back to the more substantial aspects, the AI Act I mean, in its final version, as adopted by the, agreed by and adopted by the co-legislators, has an objective to, promote trustworthy AI, and to promote trustworthy AI and human-centric AI, support innovation, while at the same time ensuring a high level of protection of three objectives: health and safety, fundamental rights, democracy, and then as part of that, democracy, environmental protection, and rule of law. That, the AI Act, takes very much into account and relies also on the 7 principles that they have been worked out by the EU AI high-level expert group in their deliverable in 2019. And this AI and these 7 principles relate, with the main threads of AI. So these 7 principles go from human agency to oversight, transparency, non-discrimination, fairness, robustness of the AI system, safety, and the societal well-being. And we can see that these are reflected also in the final text of the AI Act. Also to say that the AI Act is a horizontal law, that means it covers several areas, including law enforcement, migration, and border control, although certain specific rules are provided in order to address sensitivities in those fields. As regards the famous and also raised here from Eleonora, extra-territoriality, yes, the AI Act applies, according to the rule laid down, to providers of AI systems and deployers that are established in third countries where the output, at least the output, is used in the EU. So we don't need that one of them is established in the EU for the AI Act to apply. It is sufficient that the output is used by another party in the EU. In the scope do not fall exclusively AI systems which are exclusively put on the market in service or deployed for national security, military, or defense. Again, if a system is, let's say, a provider has several purposes, the system for all other purposes falls within the scope of the AI Act, but not the purpose of national security, military, or defense. Research activities are not covered unless, of course, within a research, an AI system that is already on the market is deployed, because this is not an AI system where still research is underway. Now, on the definition on AI systems, indeed, the AI Act has ensured that we have also aligned the text with the OECD principles, so that also machine learning and knowledge-based systems are covered. The AI Act indeed follows this so-called risk-based approach, where the 7 principles of the AI high-level expert group are reflected, and also we have this pyramid of AI systems with the banned AI systems that relate to 8 specific areas of activities and would threaten the social well-being or the human autonomy or our democratic processes, as these are all reflected in the 7 principles. For instance, that AI systems which deploy manipulative techniques and or exploit vulnerabilities to age, disability, to distort the behavior and informed decision-making. You will see also some use cases which are inspired also by recent cases of the data protection authorities, like this creating of facial recognition systems by scrapping facial images from the internet, the so-called Clearview case that has led to several enforcement actions by EU DPAs. So in the next layer of the pyramid, we have the high-level systems that, high-risk systems, which include systems that they are safety components and undergo third-party certification according to the specific EU harmonization legislation, for instance, medical devices. And we have another 8 areas of activities listed in an annex that include high-risk AI systems. There you can see that there are areas where a ban does not apply anymore. This interrelation you see with biometric systems, where we have here the all biometric identification systems, unless a system is only used for verification of an identity in order to allow access to a service or to a premise, or unless biometrics are used as a data protection enhancing measures. We have also here other biometric categorization systems that they are not banned, and these are for systems where sensitive elements relating to racial and ethnic origin or health are inferred, because these are not covered under the banned systems. These are 2 categories that we know from the data protection law as special categories and are not banned. Then it is here good to mention again, it was also a question in the yesterday's panel, whether the Commission may change this list of high-risk systems. Yes, the Commission must indeed change the use cases, not the areas of activities, when 2 conditions are fulfilled. The AI system is intended to be used as a high risk, and it is not yet covered, and the risk emanating from certain use case is equivalent to the risks already included in the annex. Then Article 7 includes a series of criteria to be taken by the Commission when it exercises this power by delegated act. It is important to mention that the Commission cannot, by delegated act, change also the 8 areas, main categories of high-risk AI systems. For this, there are a series of obligations laid down in the AI Act to ensure the 7 principles, like human autonomy, like verification by a human, and there are also obligations for deployers of the system, including this fundamental rights impact assessment, which therefore applies only for deployers. And why? Because the providers have to do a risk assessment according to their obligations. But the fundamental rights, which also include fundamental rights risk assessment, but the fundamental rights impact assessment for deployer has to take into account the specific risks. Then in the pyramid, we have the general purpose AI models and systems, and the general purpose AI models with systemic risks. Here we have also obligations that they are more limited. For the general purpose AI systems, there are mainly information and documentation obligations. And for the systemic risks, there are additional obligations, because indeed these general purpose AI models with systemic risks, they have more, they are called so because they present a higher level of risk. I can come back which, systems belong to that. We have also certain other rules, yeah? So maybe one sentence more, and I will, apart from this, we have several rules that aim to ensure that first of all, these high-level requirements, obligations, are further specified through common specifications, standards. We have provided in the AI Act a stronger participation for SMEs, academia, and civil society. And next to that, there are specific measures for innovations, including sandboxes and testing in real-world conditions. And we have also a strong enforcement that relies either on centralized enforcement for certain systems by the Commission or on big coordination between market surveillance authorities in the member states and the Commission for cases which fall in the jurisdiction of the national competent authorities, which are the market surveillance authorities.
Zoe?
Here I stop.
Yes.
We have a lot.
We have time later. Now it's time for Professor Shimpo. Thank you, Zoe. Professor Shimpo is a leading expert in Japan on technology regulative policies, and in particular in robotics. And we are here for hearing from you what is the state of the art in Japan, and especially if you want on public-private roles in the governance. Please.
Thank you. Thank you. I'm Professor Fumio Shimpo from Keio University, Japan. So I'd like to talk about the current Japanese AI governance policy and robot revolution in cybernetic avatars in cyber-physical societies. So overview, first of all, regarding the overview of the Japanese AI regulatory policies. So Japan's AI regulatory policies have adopted an approach of voluntary based guidelines and directives rather than legal regulations. The Japanese government has been proactive in this area, establishing the AI R&D draft guidelines as early as 2017. The AI policy in Japan originated from the publication of these guidelines, among other initiatives. So such proposals have also been incorporated into the OECD AI principles. Furthermore, Japan advocated for the promotion of Hiroshima AI process. So at the OECD Ministerial Council held on the 2nd and 3rd in this May 2024, so with participation from 49 countries and regions, Japan announced the formulation of the Hiroshima AI process and its friends group. So this voluntary framework aims to cooperate in the practical application of international guidelines to ensure that people worldwide can use AI safely, securely, and reliably. So however, Japan's approach faces challenges since Japan regulates AI through soft law rather than legal regulations. So there are questions about its effectiveness. So while companies with high awareness of legal compliance follow the guidelines, so these guidelines are not effective against criminal or illegal activities. So the AI governance approach that Japan has pursued consists of detailed guidelines, which can be valuable as a reference. However, I have consistently raised doubt about its effectiveness. So I'd like to introduce quickly regarding the significance and the challenges of Japan's various voluntary initiatives to promote AI governance. So first guidelines was released in 2017. So Japanese Ministry of Internal Affairs and Communications began its deliberations in February 2015. So I think it is a very early stage, the initial policy aspect of discussion. So the first step was to recognize the need for future long-term investigation into singularity. So in July 2017, the 9 principles were published as a draft of the AI research and development guidelines for international discussions. So these guidelines were developed to facilitate international collaboration and address the ethical, legal, and social implication, it has been said, and LC issues of AI technologies. And the next approach is integrating artificial intelligence with framework of Society 5.0, emphasizing the importance of creating an AI-ready society. So this document begins by highlighting the challenge modern society faces, such as environmental problems, economic disparity, and resource depletion. So Japan is uniquely positioned to address these issues using AI, particularly in light of its aging population and labor shortages. And next document is an 2019 AI utilization guidelines. So these guidelines outline the principle and practical measures for utilization of artificial intelligence, aiming to foster trust and mitigate risk while promoting the benefits of AI. So this document starts by discussing the rapid progress in AI research and development and utilization. Japan has been actively leading international discussions on AI principles, contributing significantly to framework like the OECD's AI guidelines and the G20 AI principles. So these guidelines aim to provide practical references point for AI service providers, business users, and other stakeholders to ensure responsible AI utilization. Governance, from the point of the governance of AI, governance guideline of implementation of AI principles. So governance guidelines for implementation of AI principles provides comprehensive framework to guide companies in developing and operating AI systems responsibly. Recent guidelines, so next guidelines are just published, AI guidelines for business. So this guideline is, the purpose of this guideline is to provide comprehensive guidance for business involved in development, provision, and use of AI. It aims to promote responsible AI utilization while mitigating associated risks. So, and furthermore, this guideline illustrated into this document, this is the structure of this guideline. It is a little bit complicated, so I don't have enough time to explain in details about this document. So you can find this document in English. So unfortunately, there are a few English translated documents regarding Japanese guidelines. But fortunately, this guideline has already been translated in English. So could you check later in details about these guidelines? And also, the Japanese effort is now we are focusing on the Hiroshima AI process. This effort was released in May 2013 to 23. So Hiroshima AI process represented a significant step towards creating a global framework for the responsible development and use of AI by emphasizing inclusive governance, continuous adaptation, and broad multi-stakeholder engagement. The process aimed to ensure that AI technologies are developed and deployed in a way that benefits society while addressing the potential risks. However, so as I mentioned, the AI regulation in Japan has mostly involved self-regulation and non-binding guidelines. So I believe that these approaches are problematic in terms of effectiveness and that new AI regulation needs to be disciplined through legislation and the establishment of a new supervisory bodies. So soft law and non-binding guidelines are effective insofar as they show the way to organization and private companies on how they can follow the recommendations and options of such guidelines while promoting their own interests. So, however, there is no strict law or binding regulations on specific AI issues in Japan. So, in this context, the tools of soft law may turn out to be ineffective either because they are not simply binding or they do not represent any certain guide to the conundrum of legal interpretation in Japan. So additionally, I should mention that Japan, before this conference, so the Japanese government has shifted the policy directions toward concrete legal regulations for AI. So next, so this is a little old strategies. In 2015, the Japanese government released a new robot strategy, but it has already been not new. So the Japanese Council of Technology and Innovation, CISTI, launched a research project, Moonshot Research and Project. So I also asked Professor Ugo Pagano to be a member of the participant of our research project. So this project called Moonshot type research and project, but it doesn't mean that we chose to go to the moon. So it's just a Moonshot research project. Now, currently, I'm responsible for project manager of this project. So in conclusion, I would like to introduce the future effort for now we are heading for the future of the cyber physical society. So my research project is now deploying the cybernetic avatar. So, so finally, I'd like to introduce some pictures of Japanese current development of the robot. This is the original robot, and next is also the robot. And now we are trying to make a humanoid, like Professor Ishiguro from Osaka University. He is now research and developing a human looks like robot. So these are the robots, so humanoid robot. And also the transform-like robots are also used in the future. And I encourage also all of you to visit Japan, and because now you can see the Gundam, real-size Gundam. So next year, World Expo 2025 will be held in Osaka. You can see not only the Gundam, but also the Professor Ishiguro's humanoid.
Thank you, Professor Shimpo. Now is the moment of Professor Julie Cohen, and we are eager to know your view on US governance and regulatory model for AI. Please.
Thank you so much, and thank you to the wonderful team at Torino for inviting me to participate in this panel. So what I am going to speak about is the Biden administration's executive order, Executive Order 14110 on the safe, secure, and trustworthy AI. And it is probably useful to explain to the parties in this room what an executive order even is and how it fits within the US legal system, so I will start there. An executive order is not an act of Congress, right? It is an order issued by the president regarding and in connection with the authority of the executive to manage the internal operations of the executive branch. So in that connection, the president has considerable authority to do certain things, but not really any authority to do certain other things. And that distinction is important. So with an executive order, the administration can direct government entities and agencies regarding their own use of AI and the other things they do internally. The executive has broad authority over the national security establishment and can direct those whole group of entities to take or not take certain actions, can direct the federal law enforcement authorities to behave in particular ways, can exercise commander-in-chief authority regarding the armed forces and can invoke something called the Defense Production Act, which is a statute from the 1950s, I believe, that authorizes the executive to take actions to mobilize the private sector to prioritize and produce critical strategic goods. So those are lots of different authorities, but notice that one thing I didn't say is authority to promulgate general economic legislation governing private economic actors in society regarding their conduct generally. Right. So whereas, for example, the European Union's AI Act has a lot to say about the duties and obligations of private providers of AI, and public, right? Under an executive order, the executive order has a lot to say about the duties and obligations of public entities within the executive branch, and whatever it has to say, it does have some things to say about the behavior of companies, but the authority being asserted is in a sense indirect, and that's important when you are kind of puzzling over why the executive order did or didn't do certain things. So what does it say? There's a lot about mobilizing the private sector to prioritize and mobilizing research establishments and government resources to prioritize the development of and fabrication of new chips and the production of other AI-related capacities. And that is there precisely because of that statute, the Defense Production Act. But that's a decision with consequences, right? So AI has been labeled a critical strategic good, and the things that go into AI have been labeled critical strategic goods, and that's kind of taking a national security and geopolitical lens to the question of how AI gets produced. Now, in some sense, that is what the executive is required to do in order to do anything at all. We have, as you may know, a very dysfunctional Congress. It doesn't get a lot done, and so if you're going to sit and wait for Congress to enact legislation in some sense more directly paralleling the AI Act, you're going to be waiting for a very long time, and that's one explanation for why the executive has done what it has done, but then because it's using a particular toolkit that it has, and a big tool is the Defense Production Act, it's asserting its authority in particular ways, right? It has to be said, and we may hear something about this when the next speaker speaks, that you can also view a lot of what is in the executive order through the prism of increasing kind of geopolitical tension and competition between the U.S. and China, and so it's definitely fair to say that everyone in Washington is very focused on kind of beating the Chinese to whatever it is, and that's another reason for wanting to have things produced. This is also an explanation for why, in particular, the executive order speaks about directing government agencies to perform comprehensive assessments of use of AI within critical infrastructures and within the national security establishment. So if we want to assess within that sort of frame, within its limitations, what the executive order purports to do. Ugo, you asked and Eleonora in the questions to frame the panel, is the executive order a game changer and or is a new Brussels effect at hand? So is it a game changer? No, in the sense of not being legislation directly addressed to economic actors generally, but also yes, because of the way that it does speak to economic actors. So the order directs the National Institute of Standards and Technology, along with the heads of various agencies, to build on the initial framework that NIST proposed to develop more comprehensive standards for the deployment of of AI systems, and in particular for the deployment of foundational models, to establish guidelines and best practices for developing and deploying safe, secure, and trustworthy AI systems. So a lot of soft law, similar to the Japanese model. The NIST, the National Institute of Standards and Technology, has existed for a long time pursuant to a statutory mandate to let the private sector lead in standards development. So it's really soft law. And in some sense, the question is, how is industry now going to take the ball and run with it, right, pursuant to this process that NIST is now going to convene, but with the private sector leading. The executive order speaks in particular about questions about when is it safe to use foundational models, when is it safe to publish foundational models and their model weights, when is it safe to use AI to produce synthetic biology and other potential biohazards. If you're concerned about safety and trustworthiness, it is notable that the executive order has very, very little to say about training data, right? And one could argue that something that is rather important in determining how models will perform and whether there is, in fact, safety and trustworthiness is the nature of the data sets on which the training was performed. There's a great deal of focus in this document on what's coming out the back end, right, the models and the results, and not so much focus on what's going in the front end. And if that approach is continued in the standards process that NIST is directed to conduct, then I think it's fair to say that we'll probably keep experiencing a lot of the problems that have already been recorded with the performance of foundational models, the hallucinations, the strange results that come out. There is a lot of incentive, I think, on the part of industry to keep training data more secret. And so there's a tension between secrecy and openness that is not fully surfaced in what this order does so far. If we're concerned about safety and security, it is also pretty notable that this order takes a particular stance toward the relationship between AI and sustainability that is, to say the least, a little bizarre, right? So the Secretary of Energy is directed in particular to consider how AI might be harnessed to mitigate climate change. There is not really anything in here. I guess at one point there's a mention of a global AI research agenda that the agencies are supposed to help construct, and there is a tiny little mention of sustainability in there. But in general, there's not really anything about the threats to sustainability posed by AI itself, right? Posed by the resources at every stage, from the rare earth metals to the chip manufacturing to the model training and model deployment. And none of that has anything to do with anything any agency head is instructed to do, and none of it really appears in the charge to NIST to construct a standards development process. So that's explained, I guess, in part by the kind of Defense Production Act focus and the national security focus that is being taken with this order, and that's, again, in part because those are the authorities that the executive has to wield when putting an executive order together. But it's not, and it's explainable in part also by the competition with China that has been shaping up very sharply in the last couple years, but it's unfortunate. I think that that's probably, how am I doing on time? I have 1 minute. Okay, awesome. It's noteworthy also, I think, that if this were to be a piece of economic regulation, as you all, I assume, know, when the U.S. operates in kind of the data protection space, it does so very much from a consumer protection notice and disclosure standpoint. This order urges Congress to pass a general purpose data protection law. There is such a law that is now kind of in committee and being subject to hearings. It is very much, though, still not anything that's on par with the GDPR and doesn't really yet quite deserve to be called a general data protection law, even should it pass, for reasons that we can talk about in Q&A if you want. There is a more specific charge to develop standards for watermarking and identifying AI-generated content, and there is a specific bill that has already been introduced in Congress in response to the call that might actually pass. And so that's, if I had to place a bet, I would bet that we would get that law out of Congress before we would get the general data protection law that the order urges them to develop. And I will stop there.
Thank you, Julie. And now we conclude our short world tour on governance of AI with Daniel Brick, please.
Yeah, thank you, and thank you for putting together this fascinating panel, getting beyond the Eurocentric lens we are looking at AI and data protection quite often. I'm working in the University of Cologne, at the University of Cologne, and my chair is called Chinese Legal Culture. So I'm having a background on law, but I also need to include this perspective of culture and whatever that means, actually. I try to be a little bit broader by conceptualizing my legal questions, including politics, economics, and also questions of culture and traditional values, for example. This topic here is something that got me interested when we started working on predictive policing, and we have a research project on smart courts in Cologne. So looking at how China is using technology to have a different version of a judicial system than it has now. That's more or less our goal. But when it comes to AI and AI governance, China first embarked on this right after its national pride had been aroused in May 2017, you see. At that time, DeepMind, AlphaGo, sponsored by Google, had just beaten China's Go Wunderkind Kedia, and that was really astonishing for many Chinese, even though before that South Korean had been beaten, a very good player. But still, from China's perspective, he was just Korean. So that a Chinese star could have been beaten by the system, that was really China's AI Sputnik moment. And very tellingly, just 2 months later, in July 2017, China published its national AI agenda called the Development Plan for the Next Generation of AI. So next generations, and they are even better, you see. And that is giving the tone here. In this document, China outlines its clear objective to become world leader in 2030. So watch out for that. The leadership shall not only encompass innovation or industrial strengths, but also the impacts of AI on society. And therefore, it's indispensable, needs a regulatory framework. China is aware of that. Given that background already, I think it's important to note 2 core aspects here. First of all, whenever China is addressing AI, it looks at it from the lens of race to the top. It wants to be a world leader here, and at least for the foreseeable future, this is all about this competition with the US or with the European Union when it comes to regulation also. Second thing to be noted here is that, China's AI agenda should also be decoded from the perspective of a political campaign with a populist impetus. The guy got beaten, we need better AI in China. And campaign in the sense of a classical policy implementation mechanism of China's political system, which means we have centrally identified objectives, there's a holistic perspective on implementation, meaning also that there's a multitude of public-private actors involved, and it asks for extraordinary, original, sometimes experimental approaches, especially on local level, even though the local authorities don't have any money left in their pockets nowadays in China. They are marshaled here to use the rest of what they have to build new AI super hubs, so to say. And there's a huge propaganda efforts, which may gloss over suboptimal results. A political campaign in China is doomed to be successful, and the AI campaign is doomed to be successful as well, at least on stage. Off stage, there may be many failures and shortcomings, and heads will be rolling if that's happening in China. When it comes to the regulatory framework as such, China started out with a very reasonable, I think, commendable project by first devising some ethical guidelines, undertaking an ethical risk assessment. The most prominent of these is the guidelines by the Ministry of Science and Technology, which had been published in 2021, which are called Ethical Standards for New Generation AI. These guidelines are, of course, not enforceable, but certainly possess a distinctive normative power as they are coming from the central government and directly address industry and regulators alike. Looking at the content and the distinction between hard law and soft law, to mention that really quick, in China is not so easily to be made. There's always an overlap. Looking at the content of these guidelines, it's very easy to see that China is more or less pondering the same questions as the rest of the world. Talking about human well-being, a little bit more from the group perspective than the individual perspective, but still. Talking about justice, protecting vulnerable groups, about privacy. They're talking about the controllability or the trustworthiness of AI systems. For example, by the right not to use or stop using AI. Also asking users and service providers to establish mechanisms to hold AI as such accountable, however that will play out. And they also focus on ethical awareness, which neither downplays or exaggerates the risk of AI. So that's more or less the idea of their guidelines, or their ethical guidelines. And actually it's easy to take issue with some of those Chinese ethical guidelines. For example, the notion of human rights there is certainly not compatible with that of liberal democracy, but still I see a lot of overlap here. And if we are about to cooperate with China in the field of AI, this is probably the starting point for us, because the ethical questions are the same there, here and there. The next step for China then was not to enact a specific piece of legislation, but to focus more on standardization, even though there had not been any legislation yet. In this context, it's important to understand that standard in China, I mean, much more than just a list of generally binding technical specification. Standards permeate directly into governance of societal aspects as well beyond the technical realm. And in the field of AI, they certainly do a lot of that. The core institution in this is the TC260 Committee, the National Information Security Standardization Technical Committee, which is an agency right under the very powerful China Administration of Cyberspace, who's also the data security and watchdog in China. This TC260 Committee is tasked to draft and enact standards on everything related to the digital realm, more or less. But there are also other actors when it comes to AI. For example, the Ministry of Industry and Information Technology, just another ministry here, issued in 2020 a general compass on which standards are needed for AI development in China. And this is a huge roadmap and encompasses everything from smart cities, AI in healthcare or in education, but also standards for police work or the judicial system, or for environmental governance, actually, for environmental regulations. It's a big topic in China, how to do that. But also meta standards, I would like to call them, like ethical questions or security assessments. This project is very much, it's still a work in progress, but there are some standards published and others still in the process of being drafted or undergoing final reviews. This is, by the way, also a process that involves stakeholders from industry as well as academic policy advisors. But at some point, it became very clear that China would not just rely on standardization, but also pivot toward formal legislation. The legislation we see in China is not comparable with the EU AI Act. It's not one big law. But China uses the path of legislating only areas where it apparently sees the necessity to more interventionist. Even though China is not yet really following this approach of risk classification, I haven't seen that, at least that clearly outlined in China, not yet. Quite clear that those areas of AI regulation which are covered by legislation are considered riskier than others. And those areas, for now, are deep synthesis services and generative AI. Hence, in 2023, January, China promulgated the provisions on administration of deep synthesis services. In August 2023, the measures for the administration of generative AI services. These two fields are, of course, extremely sensitive for a regime that is meticulously trying to control and steer public opinion, has no freedom of expression, and suppresses dissent of any kind. Therefore, these two pieces of legislation lay their focus on obligation for service provider to ultimately align their AI solutions with the political system, and particularly the orthodoxy of the so-called socialist core values. That's a set of values established by the party for the purpose of really streamlining societies. At least that's how I see them. China is, however, aware that this value alignment, then again, this authoritarian value alignment, I'd like to call it, must be done by the industry and not by some regulatory agency. So even the authoritarian state in China is aware that industry must be a partner in regulation for this new technology. For this purpose, then again, this TC260 committee just published last month a standard for the basic security requirements for generative artificial intelligence services, which lines out the obligation to undergo a security assessment before going public and factors in aspects such as these socialist core values. This assessment and the respective certification will be done by third parties again. And we already see that the subdivision of the AI industry is emerging in China. Alibaba has a team working on this, but also Tsinghua University or the rather officious China Academy of Information and Communication Technology. These institutions for security assessment are rather tight-lipped about their specifics, but there are some benchmarks which clearly need to be met, like alleged historical facts, which need to be aligned with China's revolutionary past or the general political direction of its country, about Taiwan, about religion, and in general, once again, about socialist core values. So censorship of generative AI in China will therefore become an industry solution, which is guided by its normative standards, of course. And, well, allow me to say this, well, generative AI in China will have a built-in hallucination, a systemic hallucination in it. What that means for the rest of the development, I'm really not sure. Lastly, I just want to mention China's offer for all those countries who may feel left behind in the AI race, in particular those who are extremely wary in allowing AI solutions from liberal democracies. Who knows what that kind of technology might spread, what kind of ideas might be spread by that. To this end, China proposed in October 2023 naturally on a BRI Summit, Belt and Road Initiatives, a global AI governance initiative. This initiative promises not only to uphold national sovereignty, non-interference in internal matters, and respect of national political and societal systems, but also advocates a benefit sharing between the big and the small countries. With this offer, China's AI, including its authoritarian value alignment, could easily be exported to many countries and they will fulfill China's agenda of AI leadership. At least that's how you could read it. To sum up, China may not be leading in AI technology in many areas right now, but its integrated approach of developing AI standards as tools for governance with some specific complementary law may be a very powerful approach to maintain a highly adaptive regulatory framework for the governance of AI, and who knows, may it's pave to a world way to global leadership. That's my understanding. Thank you.
Thank you all. And before collecting questions from the audience, I want to ask you a quick reply to your talks. So, please. If you have, of course.
No, maybe it is good to say, and in connection with what Julie has mentioned, that indeed in the EU, since we have also a union data protection law, which is again comprehensive, we are not in the same dilemma now that you are facing in the United States and the main decisions to make for a data protection law. And it is also good to say that in the AI Act, as it also states, facilitates the application of union data protection law. It does not replace it. It does not eliminate its scope, nothing of this. So now we are going to have two legal frameworks that must work together. And we don't have specific rules in the AI Act that address data protection matters. Of course, there are also for the people here, there are some more specific legal basis in some instances. We can, for instance, a processing of special categories of data to detect bias, or further processing of data in sandboxes, and the powers of the data protection data protection authorities for processing of personal data in the sandboxes. But as to the rest, and there are some other provisions, but as to the rest, the AI Act does not in any way does away or amends the data protection law. This is so this must work together, and this was also a reason that we didn't need and we didn't to have a lot of privacy-related provisions in the AI Act.
So a thing I'm actually curious about is how that's going to align with a law that you did not mention, which is the Digital Markets Act, which lists cloud services as one of the core platform services as to which a gatekeeper designation could be given, right? So it's not just, and this is like a friendly question, right? Because obviously it's nice to be in the position of having multiple legislative frameworks to reconcile, but it strikes me that it's starting to be like 12-dimensional chess, right? Because there is also going to be a need to consider whether particular AI providers might trigger in some ways the application of the Digital Markets Act as well as these other laws, yes?
They can be regulated by several laws. And there is, for instance, a reference in the AI Act for the relation of the DSA, Digital Services Act, and the AI Act, that the risk assessment under the DSA, the risk assessment for the risks under the AI Act can be made under the risk assessment provisions of the DSA. So also there a certain complementarity is expected. And also in order to reduce, as far as possible, regulatory complexity and burdens for the addressees. So.
Yes, so I felt, when I heard from the European Union approach and the US approach and Chinese approach and also Japanese approach. So we all say that safe and secure AI. From the point of the safe and secure, so it is the same word, but I think it's a very different notion of the situation. So therefore, I think we should consider from the point of what is safety and security. So this means that safety is only be achieved within the security and the trust are secured. So however, from the point of for example, now the Japanese government has been insisting that DFFT, data-free flow with trust, is one of the core values for promoting our next, so by using, for example, AI and the next emerging technologies will be necessary to learn a massive amount of the data. It's necessary to promoting and research and development. So when we think that so from the point of the security, only we can do is to, so for example, the cyber attack on like to prevent from such data from the unlawful access or any of the security. However, from the point of safety is very different notion from the point of the Japanese and also European Union US approach. So it will be achieved when the security and both security and trust will be secured. So it means the safety. So on the contrary, in the Chinese approach is very different from. So safety is for the government to protect the current regime of the government. So therefore, we should consider carefully regarding the difference between safety and security and trust.
Although I should note, I had a very lovely Chinese postdoc auditing my courses this year who said that it's just, and you said this, right? It's just alignment Chinese style, right? Everything that, his point was that everything that is called alignment by Western global North AI developers is a matter of harmonizing the outputs of such systems with Western liberal or neoliberal, if you prefer, values, and so two can play at that game. I mean, no endorsement here, but they're just two very different views of the same thing, which is how do you make the outputs of these very unpredictable creatures correspond more exactly with the values that society has decided it wants them to serve. I don't know.
Yeah, I mean, the interesting thing about that is that really that it's not the society that decides what the values are in China, but it's the regime that does that. And China is, of course, in this very, very strange situation that it lacks training data that would contradict its systems, because most of the data that would be accessible to China legally, let's say that, because they're obviously trying to get hold of other data, is already censored, and therefore it's hard to for China to find enough, well, let's say training that could trigger some responses by its generative AI that could be then flagged as wrong, and under human evaluation produce some better, more robust results in the sense of the Chinese Communist Party. So they're trying to scrape, of course, the internet for those, well, dissident statements about China. Interesting enough, in these standards that they are saying, well, we want up to 5% of illegal training data. So they are quite aware that they need that and they want that. And even the results, they're saying, well, okay, 10% of illegal outcome is okay for our AI. So when you're asking a Chinese AI 10 times, is Mao good or bad? Well, well, Mao is a 30 to 70 thing, so it may shift a little bit that results and still be safe in the sense of the Chinese Communist Party. That might be probably really a big stumbling block for China and the development of AI in that.
Except that, so here's what I think is really cool about the Chinese approach. They're paying the most attention to training data of any of the major powers, I think. Maybe correct me if I'm wrong about that. And that's something the rest of the world could learn from, although maybe not do exactly the same thing with it.
Thank you again. Any comments or questions from the public? A lot of hands.
Can you pass the microphone? Yes. Thanks so much. I'm Maria Magierska from European University Institute in Florence, and thanks so much for this panel. It was very interesting and extensive to cover all this and this global perspective that you applied here. It was very illuminatory, and that's why I think the question that hangs in the air is about this very much discussed and divisive theory of the Brussels effect and the apparent digital empires, over controversial as it is. So I was perhaps wondering about your opinion on that, whether now seeing all these developments in the AI regulation, whether it is actually, can we say, it is a Brussels effect, or is it just all these countries just coming to the regulations in on their own terms and approaches, despite what EU proposes, and just try because of different reasons than the Brussels effect, if it even exists. And the second question here is about this digital empires theory and how it is maybe translated into practice in these regulations that you were just describing. And
do you mean the Bradford book? Okay, can you restate? It's about Anu Bradford's book, but can you restate your question again?
With the mic.
No, I was just wondering, when I was listening to your descriptions of this regulation, this is this theory that hangs in the air and was very much discussed in academia, but in your opinion, how does it translate into practice in these regulations now in the political environment? And especially when we're talking the rivalry of China, whether this was actually the motivation of the Brussels effect.
Well, yeah,
Go ahead.
Go ahead. No, just really quick on the Brussels effect. Well, China would not subscribe to that, but they would rather call it, well, the UAI Act is a Beijing effect. We've been there first. It's their idea of the regulation. Of course, they were very well aware that the EU is working on that, but they really want to get ahead on that, and they really want to be faster in everything Especially also, they have this idea of, well, this international, this Schurweifage, this rule of law with international effect, and they really want to put as many standards, regulations out there before anyone else does it. So they're very proud of having done that so far.
I guess at another, I'm biased here because I wrote a review of the Brussels effect for Lawfare that disagreed with lots and lots of it. But it is important to pay attention to the fact that the Chinese are also supplying not just governments across the global south with surveillance tech, but also unbanked populations across the global south with kind of integrated payment systems, which isn't really talked about that much in that particular book. And when you're, if you can put yourself in a position to be building just sort of basic commercial systems that everybody wants to use for reasons of economic inclusion, although India is now actually trying to become a player in the across the global south for digital public infrastructure and digital payment systems as well. It's a lot more than just Brussels effect. And so it's important to be a little skeptical, even when one is in Brussels, about just how powerful the Brussels effect is.
Legally speaking, this Brussels effect would mean that if something comes from outside, needs to comply. And in a market of 450 million is not uninteresting for providers by third countries. And this is how compliance, with EU standards can be achieved, apart from any other. But we see also, I think, at least at the level of principles and taking into account what Daniel said, that of course everybody can understand the principle a bit different, or standards, as you said, and what we understand under security, safety can differ. At least we see a convergence internationally to agree on certain principles. And this has happened quickly in the last years. We have an agreement. And now, also yesterday, we had also this Seoul ministerial statement that was signed by several countries, including Japan, including, the representation of the EU, not China, to work together to assess the threshold for what constitutes a severe risk in AI. So I think it is positive to see that for this kind of technology, which maybe is one of the most complicated humanity has developed, there is a certain, common understanding and agreement to regulate it and see that the risks, they can have a worldwide effect, apart from any extra-territoriality and effect in a geographic area. But maybe if you...
I think there are other questions from the public.
Thank you for an excellent panel. Jennifer Trudeau, University of Cambridge. This question is largely directed to Julie. When you were describing the process and implications of the executive order, I was struck with the parallels with the Council of Europe's recent AI framework. Namely, when the US became more involved in the negotiations, it was very keen that private entities could have an opt-out rather than a compulsory, that they could have an opt-in rather than an opt-out, as the EU wanted. And I wondered whether, as someone who's not particularly familiar with the US domestic system, is that for practical logistical reasons, with the US not wanting to sign on to an international treaty which puts more obligations on those private entities and getting that through Congress? Or is it more for geopolitical reasons that it doesn't necessarily want to put this onus, given that so many tech titans are concentrated in the US? And if it's the latter, what do you think of the feasibility in the short to medium term of the US taking a more proactive stance when it comes to placing obligations on its private entities, either through domestic or international instruments?
It's a terrific question, and I have to plead ignorance of the Council of Europe proceeding, right? So maybe we should just talk afterward. What is interesting about the way that these debates have been unfolding in the US is that the two possible reasons to which you alluded tend to kind of blur together. And so it is quite often that one hears industry say, if you put all these obligations on us, then we won't be able to beat the Chinese, right? And the syllogism is not proven, and I would think not true. But nonetheless, it's quite politically effective. And so I doubt if you went and asked the folks who were in the Council of Europe process that they would even necessarily be able to peel those two rationales apart and disentangle them from one another.
I think the last question, because we have only 4 minutes.
Stephanie Perrin from Canada, and it's kind of a philosophical question. At least maybe you lawyers can figure out a way to draft this. But I had one of those Orwellian moments when Daniel Sprecht was talking about what the Chinese approach to basically truth was, you know, their version. And I think, at least I'm speaking from a Canadian perspective, there's some troubling material coming through in terms of speech control, even in my jurisdiction, all to control online harm. But you can see where this could take off in the hands of AI to something even Orwell couldn't have imagined. How on earth can we move towards a set of internationally recognized guidelines that would actually police the truth, granting every country a right to control its own history? So expunge the record of the Tiananmen Square, for instance, in the case of China. But, you know, this could be really quite far-reaching if it got out of control.
Yeah, the question is, how can we draft that? I really don't know.
I was afraid you'd say that.
Yes. I mean, but it's maybe a larger question, and we should ask ourselves this question maybe a little bit more, because what is truth then again when it comes to field of science? What is really secured truth, and where science still debating a lot? What will AI tell us about that? When will it discern what the right approach of good living is or not good living? That's a really, really philosophical question, I guess. And I'm afraid of that too. I don't have a good answer for that. I really see that the Chinese are certainly having this alternative truth trying to establish in its systems. To say that maybe, I think to a certain extent we will need to live with a certain margin of appreciation of the truth, to use that phrase. And then it rests on the shoulders of humans to decide what to make with that kind of truth that is AI produced. Again, that's all I have to say on that. No solution.
Time for one more question, the last one.
Yeah, Gianclodio Malgeri, Leiden University. I had also kind of a philosophical follow-up question about the convergence and possibility of the Brussels effect in the AI Act. So a comparison between Brussels effect for GDPR and for the AI regulation. GDPR was based on principles that are mostly technical, purpose limitation, data necessity, etc. While the AI Act is based on principles that are based on fundamental rights and concepts that were mentioned by Zoe, like autonomy, fairness, etc. So many commentators were seeing the risk of legal colonization of the, for example, countries or systems where fundamental rights are not like ours. So I'm wondering whether this existential difference between GDPR and AI regulation might be a limit to the Brussels effect or Washington effect, wherever, or maybe we can go back to just principles that we saw in the guidelines, but maybe it's a limited approach. So I think it's for everyone who wants to respond. Maybe Julie, I don't know.
For me, I mean, we can discuss it afterwards, but we have also the United Nations Convention on Human Rights, which is also a bedrock. So countries, they do not deviate that much, since we have also a text that we all, many countries in the world have agreed to. And now, therefore, there is also in preparation a United Nations Convention on AI. So where we are going to see same concepts. This is also an avenue for convergence. I stop here.
Yeah, I would also agree we mustn't be a contender in a race to the bottom. We need to uphold it. It's an offer we are making also, I would see that. Sure, there will be states that will not take that offer and will shield them off, and China will provide an alternative to that, I'm pretty sure, but that does not mean that we should budge on that. It's really a normative question, I think, and I would answer with a firm yes. We want the principles of human rights enshrined in our UAI Act.
I don't disagree with that, but here's my concern, okay? The way that these lovely grand principles become operationalized is through, as you said, right now anyway, the identification and mitigation of risks, right? That's like management speak already, right? And the number of different risks that need under different regimes to be identified, framed, described, and mitigated is growing exponentially because it seems to be a vocabulary that people like to use. But it's not, and I've been to a bunch of panels at this very event, right, that purported to be about how you audit for risks. It's as though you wanted to take like the good people at Deloitte and PricewaterhouseCoopers and clone them and spread them across the world, but have them become human rights auditors, which isn't even a thing, right? And there are well-known dysfunctions in even financial risk management and audit that have given us crisis after crisis. So there's like a how do you get from here to there problem, right? And when you compound to that the problem of selling it to the rest of the world, as your question asks, but you kind of run it through PricewaterhouseCoopers and you lubricate it with lots of money and private equity, it might not even come out looking the way that you think it's going to, which paradoxically will make global uptake easier. So I think that I think there are a couple more pressing problems right now than selling it to the rest of the world. And I don't really know how you solve them.
Thank you all. It has been a pleasure to have you here discussing what will be the future of converging or diverging solution among jurisdictions. And thanks for CPDP organization for the patience.